Hi, this is Srinivas Kaveti again, signing in from New York. Today we are going to talk about T visa, T for Tango. What is a T visa and who is eligible to apply for T visa? These days we've been getting a lot of phone calls to our firm that individuals who have applied for multiple h1b registrations, and after getting their H1 approved, they are getting a letter from the immigration. The letter is called Notice to Intent to Revoke Your Visa. What does that mean? What is the meaning of revocation of visa? After you get your H1B approved, and if you're working for an employer, the immigration is discovering that before you got your H1 approval, that you have applied with multiple employers. And by filing multiple applications, because you got an H1B right now, you're subjected for a punishment by the immigration. You will get a notice, the employer would get a notice called Notice to Intent to Revoke the Visa of the employee. So what is the remedy available for the employee? If you get a notice from the immigration saying that your visa is going to be revoked, and the immigration will give you at least 30 to 60 days to respond to that. Most of the times the employer is failing to disclose that or share that notice with the employee. And that's a tough situation if the employer is not sharing that notice with the employee. If the employer shares that information with the employee, what is the remedy you have? There are two scenarios here. The one scenario is if the employer has filed an application without the knowledge of employee. Let's say that when you've given your resume, your passport, and you applied with employer A. The employer A has multiple companies registered in the same location, and he has filed multiple applications for a lottery to be picked up. So that's called multiple registration of H1Bs. And you are not aware of it, and you're not a part of the conspiracy, and you did not violate the law. What is the remedy available? That is the first option. So the first option, if you are in that scenario, then you have a remedy. This amounts to labor trafficking. The conduct and the business practice of employer comes under the definition of labor trafficking. That means he has committed certain fraud or misrepresentation to the government without the knowledge, number one, and without the consent and knowledge of the employee. The employer went and filed multiple registrations. So what will happen? You can take a benefit of filing an application of T visa with the USCIS, and you have to give a complaint to the law enforcement agencies that you were put in a threat, or the employer has committed a fraud in the government, and he's not paying you the wages, and he's also giving you multiple tasks. He's not giving you any medical insurance. And there are so many immigration violations the employer commits. So if you can report that to the immigration or Department of Justice, or even the law enforcement agencies of state, or even the Attorney General, what will happen? The employees can apply for a T visa that will be valid for another 4 years, and eventually you can get a green card as well. You will also get a work authorization. You can also eventually get a travel permit. And your family members can also adjust status to T dependent. So guys, for employees who are a victim of such a labor trafficking, you have a remedy to apply for a T visa. It doesn't require any filing fees, and it doesn't require any attestation by the law enforcement agencies. So you can approach some competent lawyers, those who can help you to get a T visa. And don't abuse this because you have this information, and don't file frivolous complaints on employers, because if you are part and parcel of the conspiracy, then if you have given any false or malicious applications, you could be in trouble too. So guys, be careful, and this is not a legal advice, and don't consider this as a attorney-client privileged communication. Get in touch with some competent immigration lawyers in your area and get the help from them. They will be able to put the documents together evidence together, and then you can apply. What is the difference between a notice to intent to deny and the notice to intent to revoke? A notice to intent to deny, you get a notice from the immigration if they intend to deny your application. Let's say you filed an h1b, and if they have found some evidence thinking that it's not a bona fide employment, or if there's any immigration violation on behalf of the employer or on behalf of the employee, there could be many reasons. And if they see that there are some irregularities in the filings, there's a problem with the LCA, or the job is not bona fide, they don't have a client, there'll be umpteen reasons why immigration will come up with notice to intent to deny the application. That notice comes from the USCIS to the employer if they want to deny your application by not approving your petition. Notice to intent to revocation is after the approval of H1B or after the approval of F1 or any other visas, non-immigrant visas, sometimes even immigrant visas as well. Sometimes, somebody gets a green card and eventually immigration came to know that that's not a bona fide marriage, so they could even send you a notice saying that they intend to revoke your visa. What is the meaning of a revocation? A revocation means, it's a Latin term, it's called cancellation of your visa. It could be a non-immigrant visa, it could be a temporary one, any non-immigrant visa, until you become a citizen, they can revoke that. So intent to revoke, most of the times we are hearing that word now, Neuer. It's popularly known in the IT industry by most of the IT companies, employers and employees, they call Neuer. We received a notice called Notice to Intent to Revoke. That means when the employees have participated in the conduct of filing multiple applications and their H1 is approved. So eventually tomorrow, when the immigration discovers that you made multiple applications with different employers, then the immigration will come up with the evidence saying that A, B, C, D, you have applied to your H1B with these companies. They're giving their file numbers. They're also giving the passport numbers and the name of entity which applied for your lottery. So when they're coming up with certain notice to intent to revoke, there is a notice given to the employer. So the employers are obligated to inform the same thing to the employee, and the immigration gives you a 30 to 60 days window time to respond to that. Why? Because under the procedural due process and under the substantial due process under the Constitution of America, the immigration is an agency which is required to give a notice to the employee and to the employer that we are notifying you that we want to cancel your visa. So they're first giving you a notice. The second thing is you have an opportunity to respond to that. That is called doing a small hearing. They're asking for your explanation. So notice to intent to revoke is nothing but they're going to cancel your visa. What will happen if your visa is cancelled? And if you try to respond to them, and if they don't appreciate, if the immigration don't appreciate your explanation, your visa gets revoked. That means cancelled. If the husband's visa gets cancelled, if the children are there, or if the dependents are there, wife, all visas will be cancelled automatically. What is the remedy you have? Do you have a remedy in the immigration law? You can only make a motion to reopen. There is no appeal. And most of the times the employers are suggesting to the employees to change the employer and file a new H1B with another employers. But that is a wrong strategy. Even if you apply to another company, change of employer, your H1B will get denied. The new employer's H1B gets denied. Earlier H1B gets revoked, cancelled. And sometimes clients are calling us and saying, "Sir, can we apply for a F1 visa when we receive a Neuer?" The answer is no, because the meaning of that is because it's a poisonous tree, because you've already subjected to a violation of immigration, and then you're trying to change to another visa category. The new visa category will also be you're not qualified, you're not entitled to get a new F1 visa or a new h1b visa. Even sometimes people want to marry and file a green card at that situation as well, because you made a misrepresentation, you committed a fraud on USCIS. The immigration is going to look at it very seriously, and your new visa will not be approved, and old visa will also be denied. Once it is denied, you're within 30 days to 60 days. If you don't depart the country, you will be put on a deportation. You will get a notice to appear, and immigration might even come and arrest you, and you will be brought before the judge, and you could be arrested, and again you have to take a bail, and then you will be produced before the judge. That means you are now a removable alien, which is a bad news. So you don't want to go until that time. So you have certain remedies before that time. Get in touch with some competent immigration attorneys in your area and protect your interest. And guys, this is not a legal advice, and no attorney-client privilege applies in this case. And we are not trying to solicit any business out of this. This is only for information purposes. And our firm is assisting a lot of clients all over the world. We are located in Manhattan, New York. Get in touch with us. Our firm, Ramsey & Associates, we have been practicing immigration law for past 20 years. And thank you very much. If you like this video, please share with your friends and give us a thumbs up, encourage us, and we're going to come up with more videos like this. And please do subscribe to our channel if you did not. Thank you very much.